Welcome to Barnes & Thornburg's webinar on the European Union's General Data Protection Regulation 1 month ago. We've muted all participant lines for this webinar. If you have questions, please submit those through the questions section on the right-hand side of your computer screen. Presenters will address selected questions at the end of the session, so please feel free to type them at any time. I'll turn this over to Paula Gettert, Chair of Barnes & Thornburg's Associations and Foundations Group and a partner in our Chicago office. She has some introductory remarks, and then we'll begin the webinar. Welcome, Paula.
Hello, everyone. I am so glad that many of our friends and clients could join us today to talk about this very important topic. Barb and I put on this show a few weeks ago, and we've had many requests to repeat it because of the importance and timeliness of the topic. Indeed, I don't think we've got a month to go. It's less than a month to go. While the rest of the world is going to be preparing for a nice Memorial Day holiday, those of us in the nonprofit and meetings and association world are going to be madly scrambling to make sure that our policies are all in place so we are not blindsided by the technicalities of this new regulation and by the gruesome penalties. Barb Dunn O'Neill is our point person here at Barnes & Thornburg for these GDPR regulations, and she's going to walk us through what you need to know to prepare your organization for compliance. No use saying this shouldn't apply to us. You know, why are they darkening our door with this? This is unfair. Yes, life is unfair. As I told my young adult son earlier today, it is unfair that we are burdened with all these European regulations, but the fact of it is we are. So Barb, let's tell the people what they need to know.
Good afternoon, everyone. Thank you so much for joining us. Just to echo Paula's comments, welcome to our association and meeting industry clients and guests and friends. This program is really all about you. We are in crunch mode, no doubt, and so we welcome your questions. As Hank mentioned at the top of the hour, please type your questions into the question and answer section. We're going to try to spend at least half of our time today going through your questions. We're going to give a quick overview of the law and the regulations, and then we're going to dive right into your questions. So please, let's make it happen. Ask us as many questions as you can. We'll go through those during the webinar, and if we have others that we aren't able to address, we'll get back to you following the webinar. So just a quick recap on the GDPR. The key is that it regulates the processing of personal data. So it begs the question, what is processing and what is personal data? Well, personal data is a lot of categories, but it includes someone's name, address, email address, and even their picture. Processing that term is extremely broad. Collecting, using, transferring, monitoring, even viewing that data is enough to trigger the processing requirement. And these rights under the regulations follow EU residents no matter where they go. Major differences compared to U.S. law as data protection, data privacy. There are some states like California which are initiating some data protection, but it's still limited. This is a huge compliance challenges for all types of U.S. businesses, for-profits and not-for-profits. And there's no grandfathering provision. There's no provision that says, you have until a certain date to get compliant. May 25th is the D-Day. And as Paula mentioned, the fines are gruesome. Fines for noncompliance are up to 4% of your organization's global revenue.
Yeah, so let's pause on that for just 1 second, because I've heard so many people say, we don't keep any money in the EU. They'll never be able to enforce this fine on us. I wouldn't make that assumption. United States courts have been very generous to jurisdictions around the world in determining that if they think someone is reaching out to do business in another part of the world, they will enforce a judgment in the United States. I would not rely on a U.S. court declining to enforce a judgment made by the EU for this fine or penalty.
So So with that said, again, as much as we'd like to say, we may be difficult to try to go after a U.S.-based organization, et cetera, the reality is that that possibility exists. And, I've been frequently talking with many of you and others talking about this term risk tolerance. What is your risk tolerance? Because when it comes to compliance with these very complex regulations, you as an organization really do need to determine what your risk tolerance level is. And as Paula mentioned, the likelihood of getting a judgment in the United States based on a failure to comply with the regulations is very real. The answer to whether GDPR applies to you and your organization is likely yes. Those of you who have members residing in the European Union, yes. Our Convention and Visitor Bureau friends, hospitality industry friends on the line. You have customers in the EU. You may have members in the EU. Those of you who do meetings and events in the EU, customers, sponsors, exhibitors are in the EU.
So even if those EU parties come to the United States to exhibit, you're still caught in this, aren't you?
Exactly. And the one thing to keep in mind, and for our trade association friends who are on the line, and for the Bureau friends, your members are likely the organizations that your association represents. The law doesn't apply to a company, it applies to an individual. So the need to dig deeper as to our members, to their contact person, who's the contact person for their membership, is that person an EU resident? There's some digging to be done, and we'll get into that a little bit more in a few minutes. So having an office in the European Union, and really if you're open for business to anyone residing in the European Union, talking to a client recently who said, we don't have any members who are EU residents, but they're welcome to sign on. We'll be happy to take their dues money, in which case I say, okay, we're open for business. So in any of these instances, GDPR does apply. So the premise of GDPR is, I'll say simple, but we all know that the regulations are complex. An organization has to have a lawful basis for processing someone's personal data. It's all about this lawful basis. And so you've heard that term a lot. And you'll see on the screen there are a number of different lawful bases that would apply or could apply in any given situation. My experience thus far with our association clients, meeting and event industry clients, is that it's likely that the first two items are the ones that are going to comply or apply. The first is when the data subject has given consent. And the second when we believe the organization which holds the data believes it has a legitimate interest to use and process the data. So we're going to dig deeper into those two lawful basis, but understand there are a number of others you'll see on the screen, including performance of a contract, legal obligation, etc. So these are all the regulations. This is what the EU says. These are the lawful basis on which you can hold someone's data. So just digging into legitimate interest, using that as a lawful basis, it becomes a bit complex in terms of asserting a legitimate interest. The regulations tell us that first an organization has to identify what its legitimate interests are. For example, if I sign up to be a member of your association needs to tell me if you sign up as a member, here are the member benefits that are going to apply. And I apply to membership, I might pay my membership dues, the organization in turn processes my membership, sends me materials, tells me about educational opportunities, conferences, etc. So there's a legitimate interest in that type of transaction. And that legitimate interest under the regulations can actually include as well direct marketing to members and non-members, and also unsolicited non-commercial messages to the extent, for example, we're notifying individuals about a development in our industry. The same is true if we're notifying individuals about research. So the requirements here, we have to have a lawful basis, and we have to sufficiently and clearly articulate what our legitimate interest is, because there's a balancing test there. You know, it's the organization's legitimate interest balanced against the individuals, which these regulations, by the way, call these human rights, the human rights of an individual to protect their data. So we'll talk about in a moment legitimate interest and where sort of safe ground is for legitimate interest and where instead we would look to consent. But that's just a basis for legitimate interest. You know, one misnomer with these regulations is that we have to get consent across the board. And the reality is that's not necessarily true. As you saw from discussion of legitimate interest, there likely are situations in which your organization can assert there's a legitimate interest and therefore we don't need an individual's consent. However, consent is one of the ways that we can have a lawful basis. So I'll show you a sample consent in just a moment, but understanding the parameters, we have to allow consent to have technical settings. We have to allow an individual to do something affirmative, check a box, type their initials in the box. If it's a paper form, sign the paper. Something active, not pre-check boxes. We can't condition a particular service on consent. However, I've had a lot of you ask me this question, well, if they say no to consent, what do I do? Well, there's an exception to this, condition, and that is if the data is necessary in order to process them for the service, then we can condition consent on that. So again, using my membership application scenario, if I go through that step and I say, no, you can't, you're likely coming back, the association's coming back to me and say, we'd love you to join our organization, but we can't process it since you didn't agree to give us consent. Let me explain why, and that sort of type of outreach. So that's going to be required, and if we do a roundabout when someone says, no, I don't consent, that's the basis. We're going to have to say that that roundabout was because that data is necessary to process that service.
So, Barb, how is someone going to know if the individual they're dealing with is an EU resident? I mean, many of my clients have representatives from their U.S.-based companies that could well be EU residents.
Yeah, that's correct, Paula. It's definitely difficult in identifying an EU resident. And again, it's used as a resident as opposed to a citizen. So I'm sure we have lots of citizens of the EU residing in the United States, just as we may have U.S. citizens that are residing in the EU. This law, these regulations apply to residents equally, not necessarily tied to citizenship. So the question becomes for an organization, this is a business discussion and a business decision. Many organizations that pursue consent have determined that they're going to pursue consent across the board. So they're not necessarily looking specifically for EU residents. They're going to get the consent across the board no matter where the individuals reside. Other organizations, some of you listening, have agreed, at this point we're going to eat the elephant one bite at a time, and we're going to only apply this to EU residents. So I'm going to ask you a sorting type question if you're applying for something online, if you're applying for membership, if you're signing up for a conference, if you're buying a book. I'm going to ask you the question about resident, and if I say yes, then I'm going to get triggered into a different path. So you can't just rely on the email addresses. Some of you, that have country extensions on the email address can't just rely on that. We have to dig deeper unless we choose as an organization to get the consents across the board. So consent has to be specific as to what we're doing with that data. It can't be we can use your data for any reason under the sun, no blanket consent. And certain types of data require what the regulations call explicit consent. So what categories fall under this? Well, it could be someone's race, ethnicity, religion, political views, etc. If you're collecting that data, and some of you might be collecting that data by way of member surveys, that data requires a higher level of consent. So if you're doing that, you're going to need to beef up the consent as it relates to that information. And last on the list for consent is if you're going for consent from individuals who are under age 16, there has to be consent given by a parent or a guardian. So in the U.S., you recall there's a Children Online Protection Act. That law says people under the age of 13 have to get verifiable consent. EU says it goes to 16, under 16 has to get consent. So when we talk about privacy policy, for example, we're going to reference whether the website is designed to be used by someone who might be under that age 16. But that's an important threshold to consider as well. So as I mentioned, I have a sample consent just to give us a little bit of a reference point in what these consents might look like. The key with the consents, as I mentioned, is that we have to be specific on how you, the organization, uses a person's data. And then we also have to be specific on when your organization shares data with other parties, so vendors to execute programs and conferences, vendors to store and back up data. We have to explain those two aspects of use by the organization and use that the organization permits by third parties, by others. So you'll see sample descriptions in here. My recommendation to clients is to be as specific as you can be in different ways that data is used. You'll see I have a bit of a catch-all phrase at the end of each of these referring to other purposes the association may approve or which are related to your exempt purpose and mission. And then the key here is that in the consent, we reference to the privacy policy, and we include a link. So that, assuming this is sample consent is coming up in an online environment, the individual can click over to a live link to see your privacy policy. And as we'll talk about in a moment, the privacy policy is where we can house all the nuts and bolts that include the requirements of GDPR, the right to be erased, the right to have your data transferred, who your data protection officer is, etc. So putting that into the consent really makes it part of the consent. So you'll see in this example that if I'm following this, I'm going to either check I accept, or if I don't accept, I'll go back to the main menu. Now, whether this is me using your website or if this is me signing up for membership, again, we can't condition service on consent unless we need that data in order to process what the person asks us to do. So these are some categories, and these are broad strokes of categories in which we've talked about two of the lawful bases, legitimate interest and consent. So these are some common categories that may fit your organization, and these are broad strokes, broad parameters on how you might choose to assert either legitimate interest or consent. As a lawyer, we love disclaimers, so I will say that each of you are different, you do different things. My comments will be a generalization, broad strokes, but certainly let us know if you have specific questions that need to be answered that are relative to your organization.
So Barb, as you're going through this list, you're talking about third-party uses. That would be anything, for example, like Hertz Rent-A-Car, if they're an affinity partner of a group, or a sponsor that gets a mailing list with their sponsorship. Anyone outside the organization that's going to get access to names or contact information is going to be included in that third-party use.
Yes, absolutely, Paula. Any of you who sell a rent mailing list, this certainly triggers that. Any of you who store your data off-site, data backup providers, conference registrations, housing, etc. So it's really, that term third party really means any entity other than the organization. So just going across common categories of your organizations, our closest connection is with our members. And as we talked about with legitimate interest, there really is a legitimate interest, a lawful need for us to use a member's information in order to service their membership.
So let's complicate this a little bit. Let's say the member is a company, and they give us the name of an individual to use as their point person or voting representative. So do we have a legitimate interest with respect to that individual?
Yes, we do, because it's going, and when we say we, remember this is the association. So if the member is a company and Barbara Dunn is the contact person, then I have a lawful, legitimate interest to contact Barbara Dunn as it relates to association service. However, If now I want to take Barbara Dunn's contact information and put her on a list of affinity programs or on a mailing list we give to sponsors or exhibitors, now we're taking that narrow scope of a legitimate interest and we're stretching it likely a little bit outside its intended bounds, its intended boundaries, which causes us, obviously the lawyer side, to get nervous for you. So in my rule, and I've been talking to many of you about this, is that there's a safe harbor really as it relates to communications between an individual and the association, the individual being a member. But once we step outside the association's use to others' use, that's where consent is likely going to be your best lawful basis.
So Barb, many of our clients and friends on the phone have a family of organizations. They might have an association, a foundation, and a for-profit subsidiary. Would you consider the foundation and the for-profit subsidiary to be third parties?
It's a great question, Paula. I would say that I would look at each, even though we're perhaps all under the same umbrella because each organization is formed separately, differently, I would look at either a membership or, if I'm talking about a foundation, a donor information. I would look at each of those separately. However, if I were going for consent, I would likely include in the consent those affiliated entities. So for a lot of you that have chapters, you have divisions, et cetera, this would be appropriate that we would expand the scope of that.
So in other words, don't assume that your family members and your family of organizations are covered by legitimate interest. Consent should be the way to go unless this point gets clarified by regulations at some point in the future.
Yeah, that's absolutely correct. I mean, consent across the board, as you'll see in just this quick snapshot, is an effective way to have a lawful basis. You know, when we have a non-member who wants to sign up for a conference or purchase a book, we have a legitimate interest as to that individual. But again, we put the non-member on a list that goes to third party, we're going to need consent. What about members that have recently lapsed? None of you have that happen, I'm sure. A lot of you struggle with this. You may have members who are behind in their dues, 6 months, 12 months, et cetera. My recommendation has been to draw a scope of what you believe is to be reasonable. So many of my clients, for example, after 6 months, someone might get their final reminder. Maybe it's after 12 months. So draw a line on recently lapsed members. Those individuals likely fall within legitimate interest because we're still having this ongoing dialogue with them. But again, if that gets to third party use, that's when consent. What about people, and I've talked to a lot of you who say, I have people that lapsed 7 years ago, 10 years ago, et cetera. What do I do about that? Well, you have an opportunity to purge that data as opposed to trying to come up with a lawful basis to hold it. Now, that sparks fear in our marketing folks because they love to have that data, but yet if we hold that data, we're not going to be able to argue legitimate interest. So some of you might want to go out to those individuals and obtain consent. Others might just want to purge it.
So let's pause on that one. Is it possible for us to put into the consent form up front that you consent to us contacting you for 5 years after your membership lapses? What do you think the EU regulators are going to say about that? She's laughing. She's looking at me like, are you crazy?
Well, I tell you, certainly as much as the consent has to be specific, we don't have to put a time frame on it. We can be broad in that, and our discussion of legitimate interest could even be broader. We're going to have to make the case that legitimate interest might apply in a context in which we don't have consent from an individual. And you'll hear me say it in a few moments, document, document, document. The biggest issue if a regulator were to come knocking or questioning is the documentation that we have for the lawful basis for each of these categories of individuals. Exhibitors as well. Again, companies may exhibit, but you have exhibit booth personnel that you may want to communicate with. They may want to pick up their badge when they come to conference. Has that individual consented? What about vendors, et cetera, housing, registration, et cetera? So these are some broad strokes on the categories of when you can use that. Some of you may determine that legitimate interest is broader. You want to push that bound. Again, I go back and say it's really your risk tolerance level. If you can make the argument as to why it's a legitimate interest to communicate with someone who is a member 5 years ago, then document that basis to do so. All right, let's take a look at the privacy policy, because I mentioned in the outset when we were looking at the consent that embedding the privacy policy in the consent is really the best way to go. It's the way that we can house all the nuts and bolts of that. So what does a privacy policy have to have? Well, we have to have that this detailed description of an association's use of data. Here's a circumstance in which we can take the same description of how we use data and we can put it in the consent, as we were talking about earlier, and it's in the privacy policy. The same would be true as to how third parties use the data. We can use the same description. I've looked at, for some of you who already have your privacy policies, take a look at that if you have a description. We also have to tell people if we're collecting information like cookies or if we're using analytics like Google Analytics. We need to let them know. Also need to let them know if that they have a right to be erased or forgotten from our system on their request. Some of you have asked me, does erasure mean or transfer of data mean that I have to give an individual everything that we have about them in their membership file? The answer is no. It only applies to the data that they gave to us, specifically their profile, their name, address, etc. We need to tell an individual where the data is stored, who the data storage company is, and we also need to appoint and name a data protection officer in the policy. One recommendation I've had is to establish a separate email address for your data protection officer, so emails get routed specific to that person. We have to name an individual, and it has to be an individual who has access to leadership, officers, directors. So in an association context, this is someone at a senior level directorship position. In a corporation, bureau, et cetera, these are likely your officers or senior people. It doesn't mean you're out updating the servers and the computers all the time. It simply means that the buck stops with you. If someone says, I want to be erased, I need to make sure I honor that request.
So, Barb, on those last two, I think people need to keep in mind that you can't just put this privacy policy in place and forget about it. People change where they store their data. You know, employees come and go. So it's important to remember that you're going to have to look at this and update it as your circumstances change.
Absolutely. And, you know, one recommendation I've had to clients is once we launch the new policy, let folks know about it. Let our members know about it. Use it as a tool to show positive growth and improvement by your organization. And as Paula mentioned, the ongoing care and feeding and updating is going to be critical. So that, you know, I always say to clients, the next worst thing to not having a policy is having a policy that you don't follow. So we certainly don't want you to fall into that camp as well. Now, one last document involved here is vis-a-vis our members. So these third parties that we were talking about, I'm using the term vendors at large. Any agreements that we have with companies that assist us in our operations, so data storage, again, housing registration, any of those circumstances, even exhibitors, others who might process or use the data. These vendor contracts are important. And you've heard this term perhaps already, data processing agreements or DPAs. Some of you have already received these from your vendors. A lot of association vendors are out there with their own DPAs they're giving to clients. And other side of the coin is a recommendation that the association have its own DPA that it can give to vendors. Now that latter point is always my preference, because if we're going to draft a contract or negotiate a contract, we want to have the first opportunity. One important distinction here, the distinction between which organization is the controller and which organization is the processor. So the controller controls the relationship with the individual who gave us the data. So most often, your association will likely be the controller of data. In other circumstances, you may be the processor of data. So if I have a membership list and I want to share that membership list with a company that's going to market my trade show, I'm going to be the controller and that vendor is going to be the processor. So the processor is the entity that takes the data and does something with it. There are some circumstances in which the association might be a processor, so kind of flipped. When would those be? Well, if I receive a prospective membership list or a prospective customer list from another organization, I'm going to then be the processor. They control the relationship from the individual. They give us the data to process. So these DPAs, we have to look at them a bit fluid in that there may be instances in which the association will be the controller. That's probably the majority of the time, but there are other instances when the association will be the processor. Like any contract, always you want to have the parties' rights and responsibilities. So the regulations put a ton of responsibilities on processors and controllers, everything from data security, breach protection. We'll talk about that in a moment. So it defines each party's rights and responsibilities. And then we include indemnification. So obviously, those of you who know that term, basically it says, hey, take responsibility for your actions. I pay you to do a job. I expect you to do it right. If you don't do that job right and we get sued or we get hit with a fine, you're going to keep us whole from a financial standpoint. So the indemnification in a DPA is going to say if either of us, ideally, if we're the controller, we're going to say, hey, processor, if you mess up and we get sued, we want you to keep us whole. So that's one way we can cover our risk by indemnification. Keep in mind as well that every processor likely has a sub-processor, right? It kind of boggles your mind to think about it. But if I'm a housing and registration company, I may take your data and give it to a sub-processor to do something. Maybe it's an affiliated company. So always be mindful of the sub-processor relationship. The goal is to make sure that at each point in the food chain, we have individuals who are assuming responsibility for that role. So in the DPA, we say, hey, processor, you're going to comply, and if you use sub-processors, you're going to make sure that they comply as well. I've recommended to clients that these agreements be somewhat standalone agreements. That is, they would be in place with a vendor going forward. Some of you have asked, could it be an addendum to a contract? Sure. Certainly we could talk about different ways that you could execute that. Keep in mind, this is a triage situation that we're in right now. So take the vendors that you work most often with who have the most access to data, start with those and work your way down. That's probably the best use of time and resources as we click closer to May 25th. So this is my quick cheat sheet, 6 things to do before May 25th, 2018. First, map your data and divide it into categories. Hopefully most of you have already done this, but assessing where the data in your organization comes from. Is it members, non-members, prospects, exhibitors, sponsors, etc.? Think about those, if you will, in little buckets and lay out what buckets we have. And then the second part is determine then with each of those categories what our what our lawful basis is going to be. Are we going to assert legitimate interest, or are we going to seek consent for that category of individual? Then we develop the consent form and we process to obtain consent. Some of you, we've talked about this, of sending mailings or emails to all of your members saying, please update your member profile. Maybe in the member profile we have a consent. Some of you may have trade shows coming up. At the point of trade show registration, we might consider embedding a consent. Some of you, I've even talked about, when I go to if I'm an exhibitor booth personnel and I come to your conference to pick up my badge, and I'm an EU resident, I'm going to sign a sheet of hot pink paper so that's got the consent. So there's a variety of ways that consent can be obtained I challenge clients to look at what the most efficient way to do that is. And remember, we need to track this. Remember, document, document, document. We need to keep a record of who's sort of on the cleared list, that is, who's consented, and then obviously those that haven't. The fourth item, develop your privacy policy. Again, this is something that can be done right away. We would recommend it be put up on your website and then integrated throughout your organization, as we talked about, certainly followed. Fifth item, develop and start issuing your data processing agreements. Again, triage approach here, likely starting with the larger ones. And sixth, and most important, is the other I word. We talked about indemnification for risk protection. Now we're talking about cyber liability insurance. Many of you might have this insurance, but you may not understand its limits and its parameters. Now is the time to do that. There are carriers that are offering additional coverage for GDPR-type claims. So I definitely recommend talking with your broker and getting that information. Make a business determination as to whether you want to increase or expand the scope of your insurance coverage. And just some final notes, and thank you so much. I'm seeing all these great questions come in. Just keep in mind, as I mentioned earlier, our data protection officers, we have to decide as an organization how we're going to staff this department, who's going to be in charge, what our process is going to be internally. The second bullet is critical. If you don't already have an incident response plan for a data breach, you definitely want to develop one. The regulations say you have 72 hours at the point you find out that a breach happens to start the notification process. I was talking with a client the other day and we said, well, what if I find out about it on a Friday at 4 o'clock? Well, that clock starts ticking on Friday at 4 o'clock, and we may be carrying this over quickly over the weekend. So having the incident response plan is important. Again, document, document, document. What we are doing to comply, what our lawful bases are to hold data. Again, make sure that when we say to a resident, hey, you can ask for your data to be erased or ask for your data to be transferred, make sure we're honoring those requests. And then these last two bullets are really related, and it's somewhat going back to what we were talking about with the DPAs. Make sure the data coming into your organization is clean. I use that term clean to simply say it's coming in under a consent on a lawful basis. We understand that we have the right to use it. And then make sure the data going out the door is clean. So if we take that data, as we've talked about, and give it to a vendor, the vendor's going to want to know, I want the clean data. So again, I use that term clean just as a way to explain that that's data that's been properly procured, it's got the requisite consent, or it's got the requisite lawful basis to do that. All righty. Well, we got lots of time for questions, and we're going to dig in on your list and start going through these. And again, please type in your questions as we go. We'll continue to answer as many of these as we can.
Yeah, and Barb, I think as we dig in, we have to preface this by saying there are a lot of areas that we don't know the answer to yet, and we're not going to until these regulators see the holes in their own regulations and start supplementing them.
Absolutely, yeah. And a lot of you might hate the two-word answer that many lawyers give you, which is, it depends. Unfortunately, we're going to say that in a lot of these instances because we don't know. This will be obviously an ongoing development. So question, should we be preparing for cookie consent as part of GDPR tracking regulation? Yes. How do you prepare for that? You embed that data, that information in your privacy policy that's up on your website, and you also let attendees know or let members know by way of a consent if you're going that route. So building in cookies, building in analytics, definitely important. A distinction here about EU residents versus EU citizens. It is covering EU residents. So if you're doing a bit of a sorting question, at this point you've made a business decision to only do the compliance as it relates to EU residents, you're going to need to ask that sorting question. Are you an EU resident? If they're an EU citizen, again, residing in the U.S., this doesn't apply. Now, Maybe they have another residence in the EU. You know, this discussion can get complicated, but the question is, and the regulations are framed around EU residents. So, one of our individuals asked about a package of documents, checklists, and templates, et cetera. We're happy to work with you. As I mentioned a moment ago, you know, every association is different. Every hospitality, meaning industry organization is different. We customize the things that we work on together. But please feel free to reach out to Paula or myself. We could walk you through that separately. I think it's critical where we could support your efforts is going to be with the things that we've already talked about: data consent, data processing, and the privacy policy. So a question: our company uses manufacturer representatives in the EU, but we don't have offices in the EU or we don't have employees there. Does it apply to us? Yes. Yes. Any connection that you have with an EU resident, presumably the manufacturer's representatives do reside in the EU, that's enough to trigger GDPR compliance. Are there any safe harbors or affirmative defenses in complying with GDPR? There was an example I've heard that with regard to high-tech encrypting your data provides a safe harbor or affirmative defense. That may be the case as it relates to the necessary level of data security, but there's no safe harbor as to the lawful basis. That's something that the organizations will have to determine. And going back to the slide on lawful basis that we have, which basically sets out the different parameters. Documenting your lawful basis for holding each category of data is what's going to be, use that term safe harbor, it's what's going to be viewed as your compliance.
So keep in mind, the safe harbors are consent, legitimate interest, performance of a contract, legal obligation. Those are, you know, if some regulator writes to you and says, hey, you've been storing this data, you're going to have to pick one of those and tell them, here is our lawful basis for keeping that data.
Yeah, absolutely. And again, that's where the documentation comes in. Interesting question regarding the Florida Sunshine laws. Does that take priority over GDPR as it might relate to the right to be forgotten? Excellent question. I can't say that I have a definitive answer. Obviously, sunshine laws require, you know, open meetings and information documentation. From my standpoint, looking at the, you know, expansive nature of the regulations as they relate to an EU resident, I have to believe that the EU resident is going to have a pretty good foothold in saying that those regulations would apply. But I would definitely follow up. And again, this may be something, as Paula mentioned earlier, that's just an unanswered question at this point. Question: legitimate interest does include reaching out to the meeting type of individuals who have done business with the Bureau in the past. Yes, possibly. It depends. I got that in there. If, again, drawing that circle, is it a customer who we worked with a year ago? Is it a customer we worked with 10 years ago? Draw a line, if you will, around what time frame is reasonable for your organization and say that anything inside the line would be legitimate interest and anything outside that line would be consent required. So again, document what your strategy is.
Yeah, so here's one, though, where pigs get fat and hogs get slaughtered. 10 years is going to be too long.
Yeah.
1 year is probably okay.
Exactly, and I think there's a good rationale. If you have a rationale for saying we communicate with our customers for a year after they have a meeting and event in our city, ongoing basis, at some point, if they don't come back to our city, then they're purged from our system.
So many of our clients only hold their show every other year. That is a very good reason for stretching out the circle.
Right. And same as we talked about earlier with membership as well, membership 10 years. And if you're working with a vendor, again, same is true in terms of the vendor, the contract term as well. Do the lists provided by associations that the EU resident is a member of considered consent? The answer would be no. Consent would only have to be meet the requirements of the consent, similar to the sample that was showed, and it would have to be given by an individual. So again, for trade associations, this is a moving target. You have different people coming in and out of being the representative to the association, maybe they're your trade show contact, et cetera. So updating these lists is going to be important, but we're going to need a separate consent from each individual.
So what if they buy a list from a European association? They would need to get an indemnification from that European association that every individual on that list gave consent. And then keep in mind that that indemnification is only as good as that association's balance sheet. So, if they got a couple million in the bank, maybe that's a good indemnification. But by the way, you're over in Europe somewhere enforcing that indemnification. You guys think American lawyers are expensive. Wait till you meet our European counterparts. Let's go on to the next question, Barbara.
Excellent, Paula. Next question, can companies give consent? This is a similar question for member contacts, or does each member contact have to give individual consent? The answer is the latter. We need consent from the person, not the company. So strategy-wise, what's the best way to reach out to a company? Those individuals we interface with, who are their contacts, getting consent from those individuals separately. Some of our clients have chosen to do a survey of their company members, finding out who EU residents are, targeting consent in that manner. Again, others have targeted consent at their trade shows, at their meetings, et cetera. So there's a number of different ways to do it, but it's got to be the individual. Can we get consent via phone, and what do we need to record this? I wouldn't lean on that. I wouldn't be comfortable saying that that would be a valid consent. My recommendation, if you're going to call someone, lead them to the link. Send them to the piece of paper. Any process of that where we do have a record trail of that. For association-specific consent, as a vendor, when you receive the association membership list, can you only reach out to those people regarding the trade show or my destination in general? I'm giving you my it depends answer only because you never let your membership list out the door without putting appropriate strings on it, which means you have to receive, when you receive this data, you need to know how you can use the data. So the association needs to say, this is a one-time use for the show coming up, or this is an ongoing use for you to market your destination, et cetera. So that's definitely an agreement issue between the association and you who gets the organization that gets the mailing list. But again, remember, clean in, clean out. We still want representations. When you get that data, you want to know that you can use that data.
Yeah, so you're going to ask the association for a warranty that everyone on that list has given consent.
Yeah, interesting question about online discussion boards such as Higher Logic. So a lot of you use, maybe your boards use online discussion boards as well. Keeping in mind the data collected there may be used in some way, having an ability to have a bit of a login screen with a consent is likely a good idea. The vendors are well ahead of us on this. Our dear friends at Facebook have getting slapped around a little bit. So, they're on top of this in terms of what they do. But remember, they're only going to protect themselves. They're not protecting your organization. So if you engage in that, ask the question first to the vendor and see what we can do to expand it to get consent as well. Moving on, can you explain what you mean by no grandfathering provision? Does it mean that you can still obtain consent after May 25th? Yes. Yes, you can still obtain consent after May 25th. The grandfathering simply means that you don't have a runway of 6 months to comply. You're expected to comply starting May 25th. The fact that you're still working to comply is good, and you should continue to do that, but there's not a period of time, or it's not a situation where we said, well, we already have the data in our database prior to it, so that's all okay. It's not that type of circumstance. Question here for those that have signed up for newsletters, is that a legitimate interest? Do you have to reobtain consent? It depends on what we said at the time we got consent to send them the newsletter. Was that consent specific only to the newsletter, or was it broader? That's going to be a question, so I would recommend going back, looking at that consent. It's possible if that consent is narrow and you want to use it on a broader basis, then you would need to go back and get consent as well. Question, do nonprofits, convention bureaus need a DPO? Really, everyone needs a data protection officer, any organization. Some of you may, have heard there's some pundits saying we really don't need a DPO, and maybe you're going to inject more liability if you do have a DPO. Our answer is if you don't have a DPO, you have to document why you don't have a DPO, and you have to state what your alternate plan is to serve the DPO's role. So my recommendation, don't go there. Appoint an individual, make sure they understand the role, and let them manage that process as well. How do you erase a record if there's a financial transaction history connected to it? Need to keep 7 years. So I had a few clients ask me this question. So your auditors want to see these transactions to go back. In that regard, going back to these lawful basis, we have a lawful basis legalized to comply to have that information. But likely that data is only, doesn't necessarily have the specifics of the individual. It might have, some of you have told me it might have a batch number. It may have a bit of a record, but it doesn't necessarily have my full personal data. But that would be a lawful basis for us to keep that information. Now, again, are we going to use it outside the scope of the audit? No. If we wanted to, certainly then we would go back and get consent as well. Question about answering questions on a voluntary survey implied consent to have that data processed. What if the data is only processed in an aggregate, never used specifically for direct marketing or communication? A lot of you use surveys to gather important data. Certainly we don't want that to be a chilling effect. However, to the extent we use that data, again, this triggers the discussion of whether it's legitimate interest or whether we need consent. Some of you have told me, well, it's an anonymous survey. Really, what the regulations say is even my IT address when I respond makes that my personal data. So there isn't necessarily any anonymity in that instance. Obviously, those of you who use data on the aggregate, certainly survey data would trigger that. Also, if you ask special categories, going back to that, if you ask about race, ethnicity, religious, political affiliation, that's going to be an even harsher consent. And I have had a couple clients who have those in their member surveys that have taken those issues out.
So it's going to be important, Barb, on these surveys to put a check-the-box question, not just by filling out this survey you consent, but we got to have a little checkbox there.
Yeah, again, there's an opportunity there to get a checkbox, and so if we can use that checkbox as another way to get consent across the board, it's a great strategy to do so. Redundancy in this process isn't a bad thing. In other words, if you get the consent a number of different ways, obviously better than not having it. Question about use of analytics. So a lot of you have analytic companies, Google Analytics, for example, tracks how many people go to your website, how long they stay on the website, what information they view, etc. So if you're using any of those tools today, that's really what's meant by analytics. And that's where in your privacy policy, you would make mention that you do, in fact, use those analytics. Can data be converted to anonymous? I do not know the answer to the question. Perhaps the technical folks do. But my instinct is probably going to say no, ultimately, if I'm taking the most conservative approach. But certainly it's possible that it could be converted in some way that wouldn't be identifiable or wouldn't have a...
So no IP address, no name, nothing to link that data with the source.
Yep, that's right, Paula. So it's something that, again, a lot of that term anonymity is used a lot, and it's really just a way to, say, well, we don't have to comply. And again, I think you've heard us say compliance is important. Question, do we wait for the controller to get in touch with us about cases when you are the processor? No, actually, you as the processor can go ahead and take the lead and issue for your controllers the DPA that we talked about. In fact, a lot of my association clients on the call today, you've already received DPAs from your processors. So I'd say if you haven't heard, go ahead and take the lead, do your own. If you have heard, obviously, look at that agreement. My experience thus far has been that the agreements are all pretty even keel because they trace each party's responsibilities, which come right out of the regulations. But the distinguishing characteristic often is that those agreements do not include an indemnification provision. And as you've heard us say earlier, that becomes a critical component for this as well. How does this apply for international vendors being used if we're working with a vendor in another country to help us with our meeting? Again, they're a processor of data, so if we transfer to them, which we likely would, in order for them to do their job, they're going to have access to our data. So they're a processor. So I would say when we work with those types of vendors, we want to get them also signed up with the data processing agreement.
So I think what's important about that question is there is no safe harbor for using data processors outside the United States. It's us, it's the association, the U.S. entity as the controller who's going to get banned with the penalty no matter where our processor is.
Yeah, absolutely. And again, we have an opportunity now at Initiative. We have a question about another DPA that a group received. Uses different terms in there. It talks about data exporter, data importer. There's also reference to standard contract language by the EU. This is the first time that you've seen it. What about these provisions? What's this all about? Well, if your organization does an international transfer of data as defined by the regulations, then there are model contract provisions that are included. So when we work with clients on that, certainly it's something that if it applies to your organization, we would tell you to add that portion to your DPA. If you've received this, as you have, from another company, I would ask the question to the company, is this really required? Does our relationship trigger the requirement for that model contract language? Again, the answer may be yes, but it's definitely worth asking as well. So what about that scanning, or I collect a business card at a trade show? Is that considered consent? No. I would say that's considered legitimate interest because it's necessary for me to take your information and do something with it, call you back, thanks for coming by the booth, etc. Once we start engaging in an ongoing discussion, if you're a customer, then yes, we have a legitimate interest. If you're a prospect, we're going back to this additional consent that would be required. So keep that in mind as well as prospect data. Staff members should be educated on GDPR. What do you think? Absolutely. One thing I would say, and those of you who've heard me already say this before, the regulations are not an IT issue. They're an all-hands-on-deck issue. These regulations affect every department, from a person who's answering your phones when they come in to your most senior people who are processing data. So training is important. I think once an organization has a chance to catch its breath, doing a privacy policy, looking at the DPA, doing this consent, et cetera, then training is important. Because again, that's going to allow us to say that we continue to comply with our own policy, which is, we talked about earlier, is a challenge as well. Time for one more question or so, I think as well. Will it affect the way we run our online submission system for medical journals? Yes. What I've shared with clients on that is that with the consent that's already going to be given with these types of platforms for online submissions, I would look to embed a separate consent within that, or as a separate, checkbox screen, et cetera. So that is, in addition to the person submitting saying, my paper is valid, I own it, it's mine, we have an additional consent that says the organization can use my data in the following ways. So I see that as another opportunity to catch it on the way as well. So I think at this point we're wrapping up our time on the hour. We've got a lot of good questions. We're going to circle back with those questions that we weren't able to get with today and get back to you directly. We'd welcome your feedback. You'll be receiving a survey. We have copies of the PowerPoints that you should have received. Feel free to share those with your colleagues. We welcome any questions and comments that you have. If you need additional resources, again, please let us know. We're all in this together, so we're all happy to do that as well. And yes, so this will be recorded, as you heard. The recording will be available by the end of this week. So if you'd like a recording, please reach back out to us, and we'll send you the link. And again, my thanks to Paula, my colleagues, all of you for listening in today on this important presentation.
Great. Hope you all get in compliance and this all goes smoothly. Here's hoping. Goodbye to all.